a landmark court decision just dropped that every firearm owner in America needs to hear about. This ruling changes the entire game when it comes to your rights during police encounters. Most gun owners will go years without learning what I'm about to tell you. Let me tell you about Thomas. He's 69 years old and lives in Charlotte, North Carolina. He's a retired contractor who has carried legally for over 20 years without a single incident. Last spring, he got pulled over for a cracked windshield on his way home from a fishing trip. He told the officer he had a valid permit and was carrying on his hip. What happened next cost him nearly $9,300 in legal fees just to protect rights he already had. Stop for 5 seconds. If you're not subscribed, you're gambling with your financial future and your legal future. The next video I release could save you serious money and serious trouble, but you'll never see it unless you're subscribed. Click that button now. Thomas did everything right that evening. He was calm, polite, and transparent about his firearm, but the officer ordered him out of the truck anyway. Then came the search. His truck was gone through top to bottom. No warrant, no suspicious behavior, no smell of alcohol. Just a legal gun on the hip of a law-abiding man. They found nothing illegal because there was nothing illegal to find, but Thomas still had to hire an attorney to fight back. His case became part of a growing wave of similar incidents that eventually forced the nation's highest court to act. The ruling that came out of that wave is one of the most important decisions for gun owners in modern history. Here's what the court actually decided. Justices across the entire political spectrum agreed on this one. The decision was unanimous, which almost never happens anymore. They ruled that simply carrying a legal firearm cannot be used by itself as a reason to search you, detain you longer, or treat you as a suspect. That's the core of it. Legal behavior cannot be treated like criminal behavior just because a gun is involved. Think about what that means for your daily life. Millions of Americans carry firearms every single day. They go to the grocery store, they drive to work, they pick up their grandkids from school. They are doing nothing wrong. Before this ruling, some officers in some courts treated the presence of a gun as reason enough to dig deeper, even when everything was completely legal. That is exactly what the court just shut down. Now let me break this down in plain language so it's crystal clear. The court said that officers need what they called specific, articulable facts beyond just the presence of the gun. That phrase is important. Articulable means they have to be able to point to something real and say exactly why it made them suspicious. Not just a feeling, not just a bulge under a jacket. Something concrete, something they can describe out loud and defend in court. Let me walk you through what that looks like in practice. Say you're stopped at a checkpoint and an officer notices you're carrying. If you're calm, clear-eyed, and cooperative, and there are no open containers, no erratic behavior, and no signs of anything illegal, that officer cannot legally search your vehicle based only on the firearm. But if you're slurring your words, your hands are shaking uncontrollably, or there are other visible signs of a problem, now the officer has additional facts to point to. The gun becomes part of a larger picture. That's a crucial difference. Quick pause. What state are you watching from right now? Drop your state name in the comments below. Laws are different depending on where you live, and I want to know where my viewers are coming from. Your comment also helps this video reach more people who need this information. Comment your state right now. Let me tell you about Barbara. She's 74 years old and lives in Louisville, Kentucky. She's a retired nurse who keeps a handgun in her home for personal protection and has for decades. One evening, a neighbor called for a wellness check after not seeing Barbara for a couple of days. Officers came to her door and knocked. Barbara answered with her legally owned firearm visible in a holster on her hip, which is completely legal in her own home in every state in the country. The officers demanded to come inside. They said the gun made them concerned for community safety. Barbara let them in because she didn't know she could say no. What followed was a thorough search of her home. They went through her bedroom, her closet, her kitchen drawers. They found nothing illegal, but Barbara described feeling violated in her own house, the place she had lived for over 30 years. She told me she felt like a criminal in her own kitchen. That feeling is exactly what this ruling addresses. The court said that seeing a legal firearm on someone in their own home during a wellness check with no other indicators of danger is not enough justification for entry or a search. Barbara's situation is not unusual. Wellness checks and so-called knock and talks happen constantly across this country. Officers knock on a door, someone answers, and if a gun is visible, things can escalate very quickly. The new standard the court established protects people like Barbara from having their home searched simply because they exercise their constitutional right. From this point forward, officers conducting a wellness check need to be able to point to specific warning signs beyond just the firearm. threatening statements, signs of a struggle inside, someone calling out for help from another room. Those matter. The gun alone does not. Now let me tell you about Richard. He's 72 years old and lives in Indianapolis, Indiana. He's a former high school basketball coach who has had a concealed carry permit for 15 years. He was traveling home from visiting his daughter when he was stopped on the highway for going 4 miles over the speed limit. He notified the officer immediately, as Indiana law requires. The officer then asked him to step out of the vehicle. Richard asked politely whether he had done something wrong beyond the speed. The officer told him the firearm gave him enough reason to conduct a full search. Richard's car was searched for 45 minutes on the side of a busy highway in the rain. Passing cars slowed down, trucks honked. Richard stood on the shoulder in the cold while strangers watched officers go through his belongings. Nothing illegal was found, but the humiliation stayed with Richard for a long time. He said he felt like everything he had done right, getting the permit, following the rules, notifying the officer, had been used against him. He spent $7,850 in legal fees over the following year, challenging what happened that day. Under the new ruling the court just issued, what happened to Richard was a violation of his constitutional rights. Real quick, if you're getting value from this video, hit the like button right now. I know it sounds simple, but the algorithm uses those likes to push this information out to more gun owners who need it. That means more people learn their rights. It takes 2 seconds. Like the video now. Here's something that most coverage of this ruling is completely ignoring. This doesn't just affect people who carry outside the home. It affects everyone who owns a firearm, period. Think about it. If officers arrive at your door for any reason, even something as routine as a noise complaint or a parking issue, and they see a firearm during that interaction, they cannot use that gun as a ticket to search your home. Before this ruling, that line was blurry in many states. Courts in different parts of the country had been deciding this question differently for years. Now there is one national standard, one clear answer, and that answer protects you. Let me tell you about Nancy. She's 70 years old and lives in Portland, Oregon. She and her husband own a small farm just outside the city. They keep firearms for protection because it takes emergency services a long time to reach their property. One afternoon, someone called in a noise complaint about target shooting on their land, which is legal where they live. 2 officers arrived and knocked. Nancy answered the door, and one of the officers spotted a rifle propped just inside the entryway. The officer demanded to come in to check on the safety of the situation. What followed was a 2-hour ordeal. Officers walked through the entire farmhouse. They took photographs. They asked questions about every firearm they saw. Nancy and her husband were cooperative because they assumed they had no choice. They later learned they did have a choice. The presence of legally owned firearms on a property, in a state where owning and using them lawfully is protected, cannot serve as the trigger for a warrantless search. Nancy said afterward that she wished she had known that before they knocked. She said she would have handled the whole situation very differently. Nancy's story has a silver lining. Her husband documented everything the evening it happened. He wrote down names, badge numbers, the sequence of events, and what was said by each person. That documentation became the foundation of a successful formal complaint. Nothing major came of it legally, but the department opened an internal review. Nancy said that documentation felt like the only power they had in a situation where they felt powerless. She was right. Your ability to document is one of the most important tools you have. Think of someone who needs to hear what you've learned so far in this video. A parent, a neighbor, a friend who carries every day and has no idea this ruling even happened. Share this video with them right now. Text them the link before you finish watching. Don't wait until later, because later usually means never. Do it right now. Here's something the court said in its written opinion that I want you to hold on to. The justices wrote that treating legal gun carriers as inherently suspicious would effectively punish people for exercising a right that the Constitution specifically protects. That's remarkable language. The court isn't just saying police went too far in individual cases. They're saying that as a principle, across the whole country, you cannot be treated like a suspect simply because you are doing something that is legal. That principle matters. It matters for gun rights, and it matters for every other constitutional right you have. Let me also explain what this ruling does not do, because that part is just as important. It does not make you immune from police interaction. It does not mean you can refuse all lawful orders. It does not mean you can physically resist an officer, even if you believe the search is unconstitutional. The court was extremely clear about this. You still have to comply with lawful commands. You still have to follow your state's notification laws. What changes is what officers can do with the information that you are armed, and it changes what happens in court afterward if your rights were violated. Here's exactly what you need to do right now. I'm giving you 5 steps. Each one is specific and practical. You don't need to do all 5 today, but you do need to start on step 1 this week. Write these down. Let's go. Step 1. Look up your state's firearm notification laws today. Some states require you to immediately tell an officer you're carrying when you're stopped. Others do not require it unless the officer asks. Knowing which category your state falls into is not optional. It is the starting point for every police interaction you will ever have while carrying. Search your state name plus concealed carry notification law and read the official result. This one piece of information could prevent a misunderstanding from turning into an incident. Step 2. Practice what you are going to say before you ever need to say it. This sounds small, but it is not. When you're nervous, pulled over at night with lights flashing in your mirror, you don't want to be making up sentences on the spot. Know in advance how you'll inform an officer you're carrying. Know how you'll say clearly that you do not consent to a search. Say it out loud at home right now. The words you rehearse are the words you'll use under pressure. Don't skip this step. Step 3. Carry a small notepad or use your phone's notes app every time you're out with your firearm. If you're ever in an encounter where you feel your rights may have been violated, write down every detail the moment the encounter ends. The officer's name if you saw it, the badge number, the time and location, what was said on both sides, what orders were given. This documentation is not paranoia. It is your legal protection. Cases get won and lost on the quality of details that were or were not recorded right after an incident. Step 4. Find a Second Amendment attorney in your area before you ever need one. Look up your State Bar Association's website and search for attorneys who specialize in firearms law or constitutional rights. Write down a name and number and keep it somewhere accessible. If you're ever in a situation where an illegal search occurred, the clock starts ticking immediately. Knowing who to call before it happens means you call faster and you protect your rights better. Step 5. Share what you've learned here with at least one other gun owner this week. This ruling matters, but it only protects you if you know about it. Most gun owners don't. They're going about their daily lives completely unaware that the rules just changed in a significant way. You're ahead of them now. Help someone else get ahead too. Forward this video. Tell someone at the range. Bring it up at your next family dinner if firearms are part of the conversation. Being informed is only valuable if you use the information. Let's review what we covered today. A unanimous Supreme Court ruling just established that legal possession of a firearm cannot on its own give law enforcement justification to search you or your property. This protects your Second and Fourth Amendment rights at the same time, rather than letting one cancel out the other. You now understand the difference between an officer having specific, articulable facts versus simply seeing a legal gun. You know this applies not just to traffic stops, but to home visits, wellness checks, and other encounters. You know what to document, what to say, and how to prepare. Millions of gun owners in this country don't have this information yet. You do. Here's what I want to leave you with. This ruling is a victory, but victories on paper only matter when people know about them and use them. The officers who violated Thomas's rights on that highway shoulder, who searched Barbara's home without cause, who left Richard standing in the rain for 45 minutes, they were counting on the fact that most people don't know the law as well as they do. That advantage is now gone for you. You know the standard, you know your rights, and you know exactly what to do if those rights are ever ignored. Hold on to that knowledge. It's worth more than you might realize. If this video helped you, here's what to do next. Subscribe so you catch the next update the moment it's published. Share this with someone who carries or who owns a firearm at home. Drop a comment below with your state, or let me know if you've ever experienced a situation where you felt your rights were ignored during a police encounter. I read every comment and I respond when I can. Your engagement also helps the algorithm push this information to more gun owners who need it. Don't keep this to yourself. Important disclaimer: this video is for educational purposes only and does not constitute legal advice of any kind. Laws related to firearms, search and seizure, and police encounters vary significantly by state and by individual circumstance. Nothing in this video should be taken as a substitute for advice from a licensed attorney who is qualified in your jurisdiction. If you have been involved in an incident involving your rights as a gun owner, consult a qualified attorney before taking any legal action. What applies in one state may not apply in another, and every situation is unique to the specific facts involved.